Welcome to Employee Evaluations. I'm your host, Bruce Hurwitz of Hurwitz Strategic Staffing. I hope you'll consider us for all your staffing, career counseling, and speech writing needs. I am delighted and honored to be joined today by Lisa Browner and Ian Linder. Lisa is a partner and head of the employment law practice at the New York City law firm of Perlman & Perlman. Ian is an insurance and risk advisor with BNC Insurance and Risk Advisors. Our program today is divided into 4 sections. Lisa will start us off with a discussion of the legal matters concerned with employee evaluations. Ian will continue the conversation with insights into insurance issues which some employers may be overlooking. And I will then talk about the strategic issues surrounding employee evaluations. If you have any questions, feel free to send them to us using the chat function, and we will do our best to reply at the end of the webinar. If we don't get to your question, you can contact us directly. Tomorrow you'll receive an email with our contact information, as well as a link to the recording of today's webinar and to a short survey about the program, which we hope you will take the time to answer. It is now my pleasure to call on Lisa Browner. Lisa, welcome to the show.
Thank you very much, Bruce. I'm delighted to be here.
Thank you.
And welcome everybody today. Bruce, if you'll share your screen, I will open up my presentation.
I have stopped my share, so you can go ahead.
Terrific. Well, welcome everybody. Good afternoon. I'm going to be talking to you about some of the legal issues around performance evaluations. This is general information. It's not legal advice. But hopefully it will provide you with some cautionary tales and some tips on some best practices. So moving forward a little bit, as I said, it's not legal advice. So imagine you're a manager, you want to fire your subordinate for poor performance. And although the employee's been performing poorly for years, you've put off this uncomfortable conversation about their poor performance. In fact, you haven't given them an evaluation for the last 2 years, and the last evaluation they did get rated them as above expectations, which you had given to your employee to motivate them in the hopes that they would do a better job. Now assume that the subordinate is a different race, gender, religion, sexual orientation from their supervisor, or older from the supervisor older than the supervisor who wants to terminate them. If you fire the employee and they then sue you, alleging the termination was for discriminatory reasons, how will you defend your action as legitimate and non-discriminatory? So that's just an illustration of one of the kinds of things that I have seen that has tripped up employers in defending discrimination lawsuit. That is, terminating a poorly performing employee, and that is the reason for the termination, without any documentation to support the termination. Other kinds of cases that I've seen as a litigator are where the supervisor has rated the employee as meeting expectations or even exceeding expectations. Typically, what I've seen is they will rate the person as meeting expectations, even where the person is poorly performing. And that creates real problems for the employer and the supervisor, where the supervisor is individually sued, but for the employer as well, on defending their decision as being legitimate and non-discriminatory. Because a jury asks themselves, if the person was really performing so poorly, then why didn't the evaluation reflect that fact that the person was not meeting expectations? It's very difficult for an employer to defend their legitimate actions as legitimate and non-discriminatory when they do not have adequate documentation or any documentation, or they have documentation that contradicts the position that they're taking, that the person was a poor performer. Another issue that I've seen that has been problematic is where the evaluation form itself is inadequate. In other words, the performance appraisal form that's being used simply doesn't capture all of the categories or the criteria that the employer really needs to evaluate the employee on. So for instance, there may be certain categories and the supervisor is forced to fit their assessment into certain boxes or check off certain boxes when in fact in the person's performance that is not being captured. For instance, to give you a more specific example, employees typically have, depending on the job that they're doing, not just the hard skills of what they actually need to do, but some of the softer skills, interpersonal relations, emotional intelligence, and other things that are sometimes not adequately captured or categorized even on a performance appraisal. That's just one example. But the performance appraisal form itself may actually not be a good form or an adequate form, and which may then lead the supervisor to not accurately assessing the employee's performance because they're merely checking a box, and it's not the box that they need in order to evaluate this particular employee. And then another area of potential danger is managers putting discriminatory statements on an employee performance evaluation. What do I mean by that? Well, we'll get into this a little bit more on some do's and don'ts, but it could be a reference that a supervisor is making to an employee's legally protected category, a suggestion or an outright statement that in fact is discriminatory or shows some type of discriminatory animus. And a supervisor who is preparing an evaluation should always be thinking that in an employment discrimination case, the performance evaluation will become an exhibit that will be magnified on a screen before a jury, and that the supervisor should always be thinking about whatever I put in this evaluation could end up being public one day. I want to be careful and measured and thoughtful in what it is that I put in that evaluation, so that it then doesn't become Exhibit A in a discrimination suit. Or if it is Exhibit A, I'm proud of what I've written and it accurately reflects the person's, behavior and whether they met the objective. So here's some do's, and then we'll talk about some don'ts. So, and I'll refer back to some of the things I mentioned that, can potentially end up being problematic or end up in litigation being a problem for employers and supervisors. So some of the do's, some of the things to focus on as a best practice is have regular check-ins with your subordinates on work performance, both on the things that they're doing well and areas of opportunity and growth. Some companies, Deloitte, Accenture, National Australia Bank, and others have stopped using a performance review process, or at least that's what's been reported in the news, and instead have switched to periodic check-ins throughout the year. And that is something that employers might think about. I wouldn't say necessarily that you want to do away with, some type of written assessment, but I'm a strong believer in the idea of giving contemporaneous feedback to employees and not waiting till that one time at the end of the year. The performance review is often something that's dreaded by employees, about what's going to be said. And the evaluation of an employee's performance should never be a surprise to them. It should never come as a surprise. There should be an ongoing communication and conversation, and check-ins are a great way to do that. regular check-ins so that everybody's on the same page. And then when you do have the evaluation, whether it's quarterly or semi-annually, there aren't any surprises because you've been having check-ins all along. I would also say, and something that I don't see often, but I think is really a better practice to minimize legal risk, is to let employees know on what basis they're going to be evaluated. How is their performance going to be evaluated? Maybe if you have a performance evaluation appraisal form, show them the form, show them the categories in which their performance is going to be assessed. Again, this shouldn't be something that comes as a surprise at the end of the year where they don't know on what basis their performance and their work is being evaluated. And if you tweak your performance evaluation form during the year, then provide those changes as well so that your employees know how they're being evaluated. This is not only helpful for employees and their own morale, it's helpful for the organization, it's helpful for the company, because then the company is getting the performance that it's looking for. It knows that its employee is going to be reflective, hopefully, on what the criteria for performance evaluation will be. So that's something else I would suggest. And all of these things I'm suggesting help to minimize legal risk, because in a number of cases that I've seen, where someone is fired for legitimate non-discriminatory reasons, but that then sue, accusing the employer of discrimination, very oftentimes the employee feels blindsided. They either were not told about what their performance was, they were given an inaccurate evaluation that rated them as meeting expectations when they were not meeting expectations. The manager was not having conversations with them about their performance. And so it did come as a surprise to them. And then they assumed that there was some ulterior motive that was not a legitimate reason, because there hadn't been ongoing communication and because they hadn't received a rating that told them they weren't performing. And as I mentioned before, I think it's a better practice if you're going to do the formal written evaluations, which I think there should be some writing, then do them more often than annually. Have these check-ins. It's good for the employer and it's good for the employee, and more of this communication on the front end can help minimize the risk of problems on the back end. Make sure that you are giving accurate reflections on the evaluation, that you're not sugarcoating. And I understand there's a balance between wanting to provide real feedback and also wanting to motivate your employee to continue to do well on the things that they're doing. But the reflections should be accurate reflections. You should not be sugarcoating or giving them higher ratings than they're actually performing at, nor giving them lower ratings than they're actually performing at. And evaluations should be done when you say they're going to be done. I see plenty of employee handbooks that tell employees the evaluation is going to be done, every year, or they're done in December or January, and then they're not done consistently. They need to be done consistently to minimize the risk of an accusation of bias or discrimination. They should be done consistently on a schedule. Whenever you're doing them, if you hold them quarterly, everyone knows at the end of the quarter, there's going to be a formal evaluation, and they should be objective. You're using the same criteria to evaluate employees performing the same roles. And also, as I mentioned, the performance appraisal form you use, it's important what form you're using, and that form is going to accurately capture both hard and soft skills. And you don't just pull something off the internet. You really need to make sure that your performance appraisal template is appropriate for your work environment and for your work culture, and that it uses proper and specific metrics. The reviewer should be, of course, the person who has the most interaction and experience working with the employee, the direct supervisor, someone who really has an opportunity to evaluate the work and get input from more than one source where appropriate. It may be that an employee is working with other supervisors who also have valuable input and feedback Supervisors who are giving the evaluation should really be trained in how to conduct a performance evaluation, what the purpose of the evaluation is. What they plan to say should be reviewed by someone in human resources or someone who's trained in this area to ensure that the supervisor is not inadvertently using language that is potentially or is discriminatory. The wording needs to be very careful that the supervisor uses in preparing an evaluation, and should focus on the specific objectives that were designed for this individual to achieve, and clearly articulate the behaviors that are either positive or that need improvement. And the process should be transparent. The employee, as I said, should be explained to them how they'll be evaluated, who will evaluate them, the criteria, and they should get a copy of it. Also consider getting, where the evaluation is an evaluation of a supervisor or manager, consider getting 360-degree reviews. That means the subordinates are providing feedback and input on their supervisor, and you're getting those reviews from multiple sources. So we talked about that the feedback should be objective and accurate and consistent in the way in which it's being communicated to other employees in both manner and tone. The employee should have a chance to provide a self-assessment and to participate in the goal setting for themselves. And the metrics on the evaluation should align with the duties and expectations of the job description. These are all things that help to minimize legal risk. So if you're providing an employee with a job description, hopefully that job description is kept up to date, and whatever is in there should align with the metrics in terms of what's being expected in your performance evaluation, with some flexibility, of course, but they should generally align in some respect. Make sure that you're not asking them, in terms of their key duties, to be doing one thing on the job description, but you're evaluating them on something entirely different. That disconnect can cause, not only cause employee morale issues, but it can also make the employee question whether they're being fairly evaluated. And when they feel that they're being treated unfairly, they may sometimes then think that it's for discriminatory reasons, as opposed to simply just not being clear communication from their manager. Provide meaningful feedback and suggestions for improvement going forward. Look to the future as well, not just reflecting on what's happened before, but areas in which the employee can improve. Evaluations should be given at the same time as they are for other counterparts of that employee. The manager should be discussing the performance appraisal and evaluation. That's very important to help minimize legal risk. So many instances of cases where the employee said, my manager never discussed my evaluation with me, and as far as I knew, I was doing great. So I hear that again and again in litigation. It's also very important to get the employee's signature on the performance evaluation. Not necessarily that the employee agrees with it, but simply that they have read the evaluation. You want to get that acknowledgement. So, I've had situations where employees have just said, I refuse to sign it. Thinking that if they're signing it means they agree with everything in there, which it's not typically what the signature line is. Typically it just says, I've read and understood this, or I acknowledge that I've read it. If an employee refuses to sign it, then you might want to have a witness present that the person refused to sign, and mark on there that the employee refused to sign with the date that it was discussed with the employee. And also it's important to conduct training for managers on unconscious bias to avoid inappropriate offhand remarks on the performance evaluation form. Something that a manager might even think they're giving a person a compliment that could be construed as a comment directed to somebody because of their age or their gender or their race. So one of the things not to do, obviously, is to make comments based on or related to age, gender, gender identity, disability, medical conditions, pregnancy, caregiver, marital status, sexual orientation, or other legally protected categories on an evaluation. Now you might say, well, who would do that? Why would somebody make such a comment? Well, what ends up happening is sometimes a manager makes a comment on an evaluation without realizing that, in fact, what they're doing is they're making a statement about somebody's legally protected status. For instance, let's say a manager makes a comment, a negative comment about an employee's excessive absenteeism, when the absenteeism was in fact due to a legally protected FMLA leave, a Family and Medical Leave Act leave, where the absence is due to a reasonable accommodation for a disability or due to somebody's caregiver status. So, or comments that could be directed in some way, suggesting an age bias. Comments about somebody's energy level or needing to move more quickly or things like that that could be potentially perceived as age-based. Don't, as I mentioned, sugarcoat a performance evaluation or give a meets expectations when the employee is not meeting expectations. Don't address complaints that were made by employees. Let's say an employee had complained of sexual harassment. The fact that they made that complaint should not be referenced in a performance evaluation. Particularly if the employee ends up getting a negative evaluation, they may view that negative evaluation as retaliation for having complained, and that's retaliation is unlawful. And obviously, I'm stating the obvious to say supervisors should never retaliate against employees for making such complaints. Obviously, don't give a negative evaluation because a person, an employee engaged in protected activity, meaning that person complained of sexual harassment, because doing that is a type of retaliation. That's not to say that somebody who complained can't ever get a negative evaluation, but it's retaliatory if the negative evaluation was given because that person complained of sexual or other unlawful harassment. So, whenever a supervisor is preparing an evaluation, if you have human resources, it's a good idea to confer with human resources or legal counsel if you have any questions about what it is you're going to write, because as I mentioned, the performance evaluations will often end up as an exhibit in a plaintiff's case, an employee's case against their company, will end up as an exhibit in support of the claim of discrimination, sometimes because of what was said in the evaluation itself, sometimes, as I said, because the person consistently got favorable evaluations or meet expectations when they were fired for performance reasons. The lack of consistent, accurate, and objective evaluations do make your discrimination lawsuits more difficult to defend. It's really important that they are accurate and consistent and objective, and that, as I said, the evaluation captures the metrics that are true evaluation of your employee. If you have an employee who has an employment contract and that employee can only be fired for cause, it's important to know, well, what does the performance evaluation say about that person's performance? Because if the performance evaluation is a positive one, that's going to be challenging for an employer to say that they fired the person for cause. That will be incongruous, and then the employer could be faced with a breach of contract action as well. So we have a bunch of key takeaways: communicate regularly, no surprises at year end with an annual evaluation. Instead, think about whether you want to do regular check-ins. Identify and share with the employees how they're going to be evaluated, who's going to evaluate them, what the key metrics are that they're going to be evaluated on. Address any types of performance issues at the time, contemporaneously. Don't wait until an annual review to unload on the employee on all of the things that were wrong with their performance. it's not helpful to the company or the organization in terms of getting what they need to get from that employee, and it's certainly not helpful to the employee in terms of morale or motivation, and address the performance issues at the time they occur, and also document them on the formal reviews. Allow for self-assessment and an opportunity for the employee to participate in the goals. Use objective criteria. Ensure the reviewer is someone with knowledge of the person's performance, and be consistent and accurate. Focus on the behaviors and goals rather than attributes, like whether somebody has leadership or not. That's an attribute. Instead, focus on their behaviors and the goals you and the employee had set for themselves. And train your managers on what is the reason that we're doing this evaluation, how to manage performance, how to conduct a review. Make sure that you, as I said, provide them more frequently than annually, get the employee signature, review the job description at least annually to make sure that it's aligning with the performance evaluation that you're going to be doing in terms of what's expected of the employee. Make sure it's carefully worded, your evaluation, and confer with your legal counsel to review the appraisal templates you plan to use, the job descriptions to discuss and help with manager training on how to conduct these evaluations lawfully, and confer with your legal counsel before you terminate someone who you don't have either a performance evaluation for, or the person has positive performance evaluations that, meeting expectations evaluation or exceeding expectations. Consult with legal counsel before you decide to terminate that employee. So thank you very much. Now I pass it back to Bruce.
Thank you, Lisa.
Yes.
Appreciate it. It was great. Ian, you've got a few seconds now to share your PowerPoint with us.
Fantastic.
And
Thank you,
just to
Lisa,
remind everyone, Ian is going to now give us the insurance side of the story. So Ian, go ahead.
Thank you, Bruce, and thank you, Lisa, for that great presentation. So good afternoon, everybody. My name is Ian Linder. I'm a property and casualty insurance advisor with BNC Insurance and Risk Advisors. Our client base is predominantly small to mid-sized businesses in the greater NYC area. So today we're talking about employee performance evaluations. Are we insured? How does it relate to the topic that we're talking about today? So here's the scenario that we have to worry about, that we have to cover ourselves for. Our employee is suing us, claiming they were wronged by a performance evaluation. Are we insured for this? The answer to that's pretty simple. Yes, if we have employment practices liability insurance, which covers businesses against, which covers businesses against claims by workers that their legal rights as employees of the company have been violated. It's pretty simple. So the coverage and the type of claim that we're specifically dealing with today, employment practices liability insurance covers a lot of different things, but we're talking specifically today about negligent evaluation. So this is a type of insurance claim where an employee plaintiff asserts that the employee's performance evaluation was generally either excessively negative, unfairly low, inaccurate, or not reflective of the employee's actual higher level of performance. So obviously, when a suit arises, we have to worry about the cost to defend, attorney fees. How does this play into an employment practices liability insurance policy? So the answer is yes, employment practices liability insurance does include and does pay for the cost to defend in the court of law. It is important to note that while there are policies that, let's say you have a 1 million limit that will extend beyond that limit to provide you unlimited defense costs, generally employment practices liability, that's not the case. And your defense costs will erode your limit. So that's important when you're speaking with your insurance broker. You might not just want to have a $1 million limit, because if the defense costs could be $300,000, $400,000. And by the time the judge awards damages in that case, then your business could be paying out of pocket. The average cost of a case that's settled out of court in terms of defense costs between $10,000 to $50,000. Even when a case is dismissed, still $10,000 to $15,000. So that's still a significant amount. And that just goes back to the fact that, an employee can bring suit even if the judge, doesn't, even if it's not legitimate, they can feel that way and they can still take you to court and cost you money in defense costs. So you want to make sure that you have that EPLI policy so that you're covered. And then obviously when cases go to trial, the defense costs are much higher. So what if a suit arises from an evaluation that's over a year ago, 2 years ago? How do I know which policy is going to respond? Now, here's where the fact that an EPLI policy is on a claims-made basis is very important. So claims-made basis, what that means is that the policy that responds is going to be the policy that is in place at the time the claim arises. So even, it sounds weird, even though the performance evaluation was 2 years ago, the EPLI policy that we have in place right now is the one that's going to respond. And it will respond as long as the wrongful act or that performance evaluation that employee feels they were wronged by was after the retroactive date. And the retroactive date is the date that your company first purchased employment practices liability insurance. It's important to know that retroactive date only matters if you've consecutively had EPLI insurance. So that's why it's so important to not only have EPLI insurance, but to maintain it over years and years consecutively. Tail coverage is also very important when we're talking about a policy that's on a claims-made basis. What if your company is going out of business or plans to, like we've seen so many have to do during the pandemic? It's important to know that on a policy with a claims-made basis, you're going to have to purchase tail coverage. Generally, businesses will purchase it up to 6 years to comply with the statute of limitations, because if you close your business and you cancel your policies, if there's a suit that arises after your company closes down, you're not going to have coverage. So that's very important to make sure that you talk, if you're going out of business, to make sure you talk to your insurance broker about tail coverage. So these are some things. Obviously, there is more coverage afforded under EPLI policies other than just negligent evaluation. Here are some more reasons why it's even more important to have an EPLI policy. It covers things like your employees suing you due to wrongful termination, discrimination, sexual harassment. Retaliation was a key one that Lisa touched on. If an employee feels like they were treated a certain way because they brought up one of these concerns because of a performance evaluation or for another reason in the workplace, and they feel like they're being treated differently in the workplace, they could sue their employer. Defamation, invasion of privacy, failure to promote, or deprivation of a career opportunity. These are all things that could happen in the workplace that are covered under EPLI. So Advising is one of the leaders in insurance research, and they recently published a comprehensive EPLI study. So what did they find? They found that surprisingly, the vast majority of companies really don't have EPLI insurance in the United States. Only 23% of companies with fewer than 100 employees purchase EPLI insurance. That number is only 34% for companies with 500 to 700 employees, and only 40% with businesses that employ over 1,000 people. So what you can see is that there are clearly too many businesses that don't have this coverage, and you might ask why. So one of the most major reasons for this is because businesses actually believe that they're covered elsewhere. If you talk to your insurance broker, they will tell you a standard general liability policy, which a lot of businesses believe they are afforded employment practices liability coverage under, it actually doesn't cover you for employment practices related claims. Almost every, if not every single general liability policy has a specific employment practices related exclusion on it. A lot of times businesses will have their liability coverage included on a business owner or a package policy, but it is worth mentioning that even when there is included EPLI coverage on a business owner or a package policy, it's almost always a very limited form of employment practices liability coverage. So your best bet is always a standalone employment practices liability insurance policy. So what determines the cost? Obviously, the number of employees, that makes a lot of sense, right? If we're going to have more employees, we have a greater possibility of a lawsuit from one of our employees. The amount of coverage purchased, whether we want a $1 million limit, which is the minimum that we recommend for our clients, whether you want a 2 million limit, whether you want a 3 million limit. Another thing that's really important that Lisa also touched on is what kind of HR policies do you have in place with regard to anti-discrimination and anti-harassment? Every time that we have to apply for EPLI insurance for one of our clients, the insurance carrier wants to review a policy, a copy of the company's employee handbook. So this is very important because not all companies have this. A lot of times we're applying for the coverage and we realize the company doesn't even have this, and we have to refer them to somebody like Lisa who can help with that. Claims history is obviously very important. How many claims have they had? Has your business had related to employment practices? If you have more claims, it's riskier to insure you. That's just how it is in any type of insurance. But typically, from a cost standpoint, we're looking at about $800 to $3,000 for small to mid-sized businesses. That's generally what we're looking at. So when you think about going back to previous slides where I mentioned that the vast majority of companies really don't have this coverage, and the potential for these major lawsuits and legal costs, it's really surprising when you consider the small cost on an annual basis. So that's all I have for you guys. Really appreciate your time. Again, my firm is BNC Insurance and Risk Advisors. As of recently, we're part of the Acrisure family of brokerages, and which makes us technically the 9th largest broker in the world, actually. And aside from employment practices liability insurance, there are a number of other policies that we can help manage and put your company in a great position, both in the short term and the long term. And with that, I'm going to turn it back to Bruce.
Ian, thank you very much. You and Lisa have really set the bar high for me, but I like that. So thank you both. I just want to remind all of our attendees that if you have any questions, just use the chat function and we'll do our best to respond at the conclusion of my address. I'd now like to take a few minutes to share with you my thoughts on evaluation, but from the perspective of employment and the impact of employment on a company's growth potential. As we all know, evaluations, critiques can be positive or negative. But for them to be effective, they have to be heard. And for them to be heard, the critic, the supervisor, the evaluator, has to be respected. Supervisees see everything. And if a supervisor is a do as I say, not as I do type of person, they're not going to be respected and they'll not be listened to. They'll be laughed at. So, but let's assume that the supervisor is respected. The supervisee has to know how to accept criticism. I was always taught, consider the source when doing research, or accept the criticism in the spirit in which it is meant. Of course, some employees may think, as Lisa alluded to, that the intent of the supervisor is malicious, but it's not always, and that should be very rare. The intent should be to help the employee to grow. So the inability of the supervisee to know how to accept criticism is a problem today, because a lot of younger employees, generation, choose whichever one you want to use, there are so many of them, I'm confused between them. But the younger employees, the college graduates, the recent college graduates, have been indoctrinated with the philosophy that any criticism is a personal attack and must be avoided. If you criticize somebody and they happen to be a member of a protected class, you're going to be viewed as a bigot, or they will slap an ism on you. So they never know how to criticize, nor do they know how to accept criticism. So they don't criticize. And for that matter, they don't express an opinion. Now, there are others who know that their opinions simply are not going to be acceptable. They're going to wind up being in the minority. So they learn to keep their opinions to themselves. So they also don't know how to criticize. Both groups also have something in common: social media. With the possible exception of LinkedIn, anyone can open an account on Twitter, on Facebook, use an assumed name, and say whatever they want. It's what I call the armor of anonymity. You don't have that in the workplace. If you express your opinion, you're going to have to defend it. So since you can't hide behind anonymity, you have to accept the consequences of your statements, even if you're just giving your opinion about a policy, about a program. You're going to have to defend yourself. They don't know how to do that, so they remain silent. And this means that employers will not benefit from their opinions, which should be, at least in part, one of the reasons why they hired them. So employers need to teach their employees how to give and accept criticism. And the evaluation process is the perfect place to do that. And when I say process, I don't mean simply on their anniversary. I spoke earlier about respect. Because of the time constraints, I want to focus on what I consider to be the most important thing a supervisor can do to gain respect, to earn respect. Remember, respect is not given, it is earned. And that is to show appreciation. I once had a career counseling client who came to me and desperately wanted to leave his job. He felt totally unappreciated. He had done some very impressive things. It only took a matter of weeks for him to get a new job. I instructed him, I helped him to write his letter of resignation. I instructed him that if he was to be asked or offered a counteroffer, he should reject it. It's always a bad idea. That's not the topic of today's discussion, so I won't go any further into that. He submitted the letter. His supervisor was shocked. His supervisor's supervisor was shocked, and the owner of the company was a very unhappy man. And they didn't understand why. So they asked him. And he said, well, I'm unappreciated. You don't appreciate me. And they all said, what are you talking about? We appreciate you. We value you. And he said, well, it's the first time I'm hearing it. The first employee review I had was, let's call it, very structured. My supervisor explained to me that she had a form from HR with 2 columns. One column had the responsibilities that were listed in my job description. And the other column was for her to give me a score, 1, 2, or 3. I don't remember which was the highest, but she said that she could not give me 100% of the highest score. She had to give me a couple of the others. And that's what happened. I got all the maximum number of higher scores and then a couple of the others. Then she told me I needed to sign the evaluation, as Lisa said, and that I could comment on it. Well, I didn't have any problem signing it. I wasn't actually going to argue and say I didn't do a great job. But the comment on sort of confused me. So I asked for permission to take it home and to think about it. And she looked at me, was very perplexed. I gave it to me. I went home. And I couldn't imagine that she was asking me to comment on the actual evaluation, but rather on the process. So that's what I did. And I had comments about the process, and I made them, and HR did not like them. What I wrote basically was that the process was faulty. If I had done something well, I should have heard about it immediately and not on my anniversary. If I had done something poorly, then even more so that I could correct what I was doing wrong and not repeat it. But then I said, or I wrote, I'm being reviewed on things that I was hired to do. I should be doing those things. I'm doing a lot more, I said. Why doesn't the evaluation pertain to any of that? For me, the definition of failure on the job is if when you leave, your replacement gets the same job description that you received when you were hired. That means there was no growth. That means you didn't do anything over and above what you were hired to do. My view is that should be the focus, at least of the annual evaluation. And I agree with something that Lisa said, agree with everything Lisa said, but you can have quarterly evaluations. It doesn't have to just be annual. So to summarize, employees need to understand criticism. Supervisors need to earn respect, the respect of their supervisees. And employees should be given immediate feedback, praise when appropriate, criticism when necessary. And finally, evaluations should focus on employee growth. Because if employees don't grow, the company won't grow. That should be the expectation. You're going to grow on your job. If you're not growing, you're stagnating. If you're stagnating, the company is stagnating, and no company that stagnates survives. So employee evaluation should be at the heart of business growth strategies. Grow your employees, and you'll grow your business. Now, bear with me. I want to bring back Lisa and Ian. I want to thank you both profusely. You did a great job. And I think we have time for one, maybe two questions. So I think the first question is for both of you. What is, I understand the question because I come from nursing homes. And there are every month somebody files a frivolous suit and it's just not worth it. And the nursing home would agree to settle out of court, and that's what they want. They want the $10,000, the $20,000, what have you. It doesn't cost them any money. The lawyer gets his or her percentage, and they're happy, and our insurance rates go up. Can both of you comment on the issue of frivolous lawsuits?
Well, when you say frivolous lawsuits, I mean, it's really going to depend on what's being alleged. There's frivolous and there's meritless. In other words, somebody thinks they were terminated, let's say, for discriminatory reasons, when in fact it was performance reasons. So, it could be meritless lawsuit. There's no merit to the plaintiff's claim, but they believe that because they were never told they were doing a bad job. Maybe their supervisor was in a different legally protected category than they were. They didn't have a good working relationship with the supervisor, and they felt that there were ulterior motives that were discriminatory, but they may not have any evidence of that. They may not have any discriminatory comments. All they may have is they were terminated, and there aren't evaluations to support that, or other documentation to support that. So that would be a type of, potentially a meritless claim, but nonetheless may be difficult to defend on the employer side because there's no documentation supporting the legitimate reason for the termination. So that's what I would say. And then I do want to get to one of the attendees has a question that I would also want to address.
Ian, you want to add anything on frivolous, and then we'll get to the question.
What I would add to that, and that is a great question. I was always taught, and especially in my industry and my training, you focus on that which you can control. So I can't tell my clients that they have any control over whether somebody frivolously sues them or meritlessly sues them. But what you might have control over is the procedures and the protocols that you have in place to avoid those things, and having the proper coverage to protect you when those things do happen. And it is true, though, these frivolous lawsuits and this, overall increasingly litigious society that we're living in, it is driving up insurance costs. It is true. And nobody is able to prevent, a frivolous lawsuit. All we can control is the protocols and the procedures that we have in place, and protecting ourselves in terms of obtaining the proper coverage. That's really all the control that we have.
I'd also add that frivolous is different from meritless. So in the legal context, if somebody files a frivolous lawsuit, in other words, the plaintiff's attorney did not do a good faith investigation of the facts before filing the lawsuit, the defending lawyer can seek sanctions against the attorney, can write a letter telling them, that to withdraw the claim, that it's if it's frivolous, I think of it as something that's actually brought in bad faith, where no investigation was done by the attorney, which ethically they need to do before they bring the lawsuit. So that's a different situation. So, a company or a nonprofit organization could potentially, their attorney could seek sanctions against the plaintiff's attorney for bringing something that's frivolous, as opposed to something that ultimately a judge decides has no merit, and the judge dismisses it. So
questions in the chat room. One I want to get to, because we only have a few minutes left, it intrigues me, and I don't have an answer for it. So I'm throwing the two of you under the bus. What happens when senior management is changed? All of a sudden, you've got new people, and it's time for annual evaluations, and they basically don't know anybody.
Well, here's what I would say. I would say, first of all, the new management, it's a good idea for them to be meeting with the subordinates at the outset when they're coming in to, to develop the working relationship, and also to be able to set, have a conversation about the expectations of the position, to hear from the employee what the employee's been doing, have a sense of whether the job description matches what the person is doing actually, and if not, update the job description accordingly. And obviously that new manager should have a conversation with this employee about what the expectations are in the role, what this manager, what their management style is like, their communication style, and what their expectations are, and have a conversation about it. And also, make note on the evaluation that they've only had X number of months to evaluate this person. If the former supervisor is still there, let's say at the company, but maybe in a different role, then get input from other people that have had an opportunity during the course of that year to evaluate. Have those folks weigh in on the evaluation, actually contribute their own comments, so that really the employee has a fair and robust evaluation. But certainly I think the supervisor, the new management, would want to qualify, I've only had a month, or I've only had 2 months to evaluate the performance of this person. Let's meet in another 3 or 4 months or something like that, which is another reason why I think this notion of the annual evaluation is just really an old, archaic and not very effective system from either end, because very oftentimes the manager may only remember what happened the last few months, and that may be more heavily weighted in the annual evaluation, and the things that happened earlier in the year may have been forgotten. So I would say for new management coming in, again, have this ongoing check-in, and if you have to do the formal annual evaluation, then they would reflect, I've only had a month, or I've only had 2 months to evaluate this person's performance. I would like to meet with them again in another 3 to 4 months. But certainly have conversations first with the employee and do your listening tour on what's working well and what kinds of things the employee is actually working on.
Ian, we only have a minute or two left. What would you like to add?
Yeah, the only thing that I would add to that, Bruce, and thank you, Lisa, for that, is I have seen, I have dealt with a client where they had employment practices related claims and a pretty bad claim history, and it was driving up their insurance rates. And they did have to bring in a new senior management team or part of that team in relation to that. And as insurance advisors, it's always our duty to fight on behalf of our clients to obtain the best terms and conditions possible in the insurance marketplace. So that is something that we use as a way to say, hey, look, here's the reason why they were having these claims and these issues. However, this is what they're doing to work through these issues. And they've established a new senior management team, specifically these positions. And oftentimes it will help us to obtain better terms and conditions in the marketplace.
Ian, Lisa, I want to thank you both. I, of course, want to thank all of our attendees for joining us. As I said at the beginning, you will be receiving an email where you will have our contact information, and we will be delighted to respond to any questions you may have. Thank you.
Thank you.
Have a great day and stay safe.
Thank you, everybody.
Thank you, everyone.